This matter comes before the court, Daniel Jowiski versus Leslie Gustafson-Jowiski. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock. Please don't use the names of any minors or victims, as we are recording this video and it will be posted on the court's YouTube channel. The court's read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the court, my name is Attorney David Berta. I represent the appellant Leslie Gustafson-Jowiski. I would like to reserve 5 minutes if necessary. Thank you. Your Honors, this matter involves, in essence, the drafting and the following through on a qualified domestic relations order. In this matter, the parties were married in 1982. They separated legally in 1996. A qualified domestic relations order was drafted in 1997, was approved by the court at that time. That domestic relations order divided 1/2 of the fraction of the numerator, which is the number of years of his pension. In other words, subject to the Hoyt formula. So I won't have to reiterate that, based upon the benefits received. However, sometime in 2020, some 20 years plus, the appellee filed a motion to, and he entitled it, a motion to modify and clarify the judgment regarding the retirement pension. After a series of pre-trials, the matter was set for hearing on all pending motions. Originally, this matter was set on August 19, 2021. My client appeared by phone and apparently made the remark, which I did hear, as an MCP. She did not indicate what that meant. The magistrate assumed the remark meant male chauvinist pig and found her in contempt of court that time. Imposed a 7-day jail sentence and imposed a $100 fine. The jail sentence was suspended on the condition that she pay $100 by the next court date. However, the matter did come to finally on September 7th on all pending motions. And at that time, the appellant did not pay the $100 fine before that date. At the hearing, there was an expert for the QDRO group. What had happened was Ford Motor Company had actually prepared, it looked at the QDRO and devised the way to split the benefits, which is 1/2 to each party based upon the years of service. So Ms. Gustafson would get approximately $1,000, $1,100. It's based upon the funds that were in that and the dates of marriage to the date of separation. Now, what the appellee had done was he had actually put additional funds in this same retirement account after the date of divorce. So he continued to put more money in. I believe his testimony was he had an offer of some sort of early retirement. So he continued to put more money in. And as he put more money in, obviously, the retirement plan grew. Now, Ford didn't pay any attention to that per se because they did exactly what the qualified domestic relations order said. They divided it based upon the years of marriage to the date of separation. And once they got that, that's how they came to that agreement. However, the appellee says, no, that's not what I meant, even though he testified in the brief, and it is in my brief, that he waited some 20 years after he figured out that he began contributing additional money to this plan to ask the court to amend, and I think modify is the proper word, the original QDRO. If you look on page 6 of my brief, actually she was to receive $1,156.28 based upon that retirement plan. In the transcript did provide, and I believe so, and I have highlighted in my brief once again on page 6, I asked, the answer to by the QDRO group was the individual for the expert, Mr. Myers. He says, this is how the original QDRO was drafted. The original QDRO was drafted to take the coverture and multiply it by the final benefits that came out of that plan. It did not distinguish between contributory and non-contributory benefits. Contributory benefits, obviously, he added additional amounts after the retirement. So the plan did implement the QDRO as it was drafted. That's his testimony. Question from me. So the plan, in your opinion, was correct, at least in Ford's analysis is correct. You took the original QDRO as it is today. His answer was yes. And I asked him again whether that QDRO had been separated contributions from non-contributions, did not make it strictly through Ford. He said that might have been, he says, answer, well, yes, I believe what you're saying is my analysis would be if we drafted, we would need to draft an amended qualified domestic relations order to effectuate it. The appellee himself admitted that the intent of the parties was realized by the original QDRO at the time of its creation. That's on page 37 of the transcript. He admitted that he discovered in 2020 that his retirement amount might not have been what he hoped for, and he waited an additional 20 years to file a motion changing the same. That's on page 38. The magistrate then issued a decision on this matter, on all matters. That decision was issued. Appellant filed an objection. That objection was actually voided by the court, and that's where we come in with the $100 fine, indicating because the $100 was not paid, it was a legal fiction, it would not take that complaint. At that point in time, objection. At that point in time, my client did file timely with the Court of Appeals regarding denial of what we believe is the denial of the objection. Now, the question on the QDRO issue comes into play, quite frankly, that this is a motion to modify. And I did cite some law, Walsh versus Walsh, Ohio State Supreme Court in 2019, which held that property division in a final decree of divorce is not modifiable unless both parties consent. In this case, Ms. Gustafson did not consent. In that case, there was a little bit about a military pension, and what the court did was just kind of fudge some numbers and say, well, we'll just say they're married 2 years longer or less to make it work. And in this case, what it really happened, Your Honors, is unfortunately, appellee kept adding money to the case. So there was no need to modify this. He could have not placed money in that account whatsoever. The QDRO is actually addressed as it was supposed to be addressed. The original decree provided for that property distribution. It was drafted in accordance. The expert and the appellee agreed that that was a proper QDRO based upon the wording of the original decree, etc. There's no question that they used the terms of the marriage in this case. They certainly did not take additional time. There was additional money because he kept adding additional money, but that went towards all years of service, not just later years of service. The expert for the QDRO, the Medina Qdro group, indicated that they would have drafted it differently. However, they said it was drafted properly based upon the party's intent at the time. Your Honor, because of that, Your Honors, I believe that this would be an improper modification of the original division of property, which is not allowed under the Ohio Revised Code unless both parties consent to that. Civil Rule 60B, motion to modify the property of a final decree or decision. I believe that's what this court should look at. Because appellee specifically entitled his motion a motion to modify. And Walsh in the court held that a property division in a final decree of divorce is not modifiable unless both parties consent. For that reason, I believe that it was properly drafted, and my client should in fact retain the amount of money that was initially indicated in the original QDRO.
Attorney Berta?
Yes.
I have a quick question.
Yeah.
It's my understanding that your client prepared and filed objections to the magistrate's decision. Those objections were accepted by the clerk, but then there's a later order that voids them. I guess the question is, and we'll find out in due course, but are those objections that were stricken, for lack of a better term, are they in our record, or we will not see them?
No, they should be in your record. Well, that's a great question, Your Honor. You know what? I think the court ordered the clerk to remove those from the file itself. So you're correct. He indicated, the court did, that they were in fact filed. I think that's in his entry. Then they were removed. So my argument goes on to the second part, exactly that this court took away a substantive right, whether that's $100 fine or what, if she made it or not. You can't just say, hey, until you pay $100, you're not going to be arguing in this court. And I know the appellee, and I will save that for my final 5 minutes, cited an order from the district court, but I don't think it applies because that case, an individual was filing 19 separate times to reopen a lawsuit. They've already heard the facts of it. He said, it's enough. You're filing the same motion over and over. And until you pay this fine, we're not going to hear you anymore. This case, she never got one bite at the apple. The idea was, I believe the court was arbitrary in that regard and did not exercise due diligence in their judgment. It was an exercise of passion or bias, which I did cite on page 9 of my brief. That was a case, I believe the court would allowed it to happen. They could have, in fact, found that my client did not pay the $100 fine, done whatever they had wanted to. My client did not pay the fine for fear of waiving any objection to the contempt finding. The contempt finding was not filed at that time because the case was not concluded. My client did not feel that that was an objectionable order yet until the case was final. And at that time, she did object. I believe the court abused its discretion by completely throwing out the objections. The only course of conduct my client had then was to come to the Court of Appeals. How the court would have decided the issue, I don't know. I understand, and I will touch on this, that we can say, well, this may be somewhat inequitable in a sense because the individual placed money in a QDRO that he did after the marriage. That was quite frankly a very dumb decision. He admitted that he could have actually done it separate.
Counsel, you're just now reaching into that 5 minutes of rebuttal. You can continue or reserve as you see fit.
I will reserve it at this point. Thank you, Your Honor.
Certainly. Attorney Bremke?
Yes, Your Honors. Giovanna Bremke on behalf of Mr. Dan Jowiski. As Attorney Berta noted, the parties were married in 1982. They separated it, actually had a legal separation in 1996 and were divorced in 1997. At that time, a CUJRA was filed, and my client had been working at Ford Motor Company. He continued working at Ford Motor Company until his retirement in December of 2019. At that time, it's the first time he received a statement that was sort of itemized as to the split. At the time he had retired, that's when he had gotten it. And he realized that there was a miscalculation there. And that prompted him to file a motion. And I will note, Attorney Berta called it a motion to modify. It's actually a motion to modify or clarify. So that is also in the title of the motion, is to clarify. He filed the motion to correct the situation. There were status hearings that ultimately resulted in a hearing. At that hearing, there was 2 witnesses, my client and James Myers of QDRO Consultants. And he was, actually Attorney Berta's client had originally asked that QDRO Consultants be hired to review the situation. They were hired, Mr. Myers was hired, and he testified, but on behalf of my client, he had testified that instead of the $1,689 per month that Attorney Berta's client should receive, it should actually be $287.08. Mrs. Jowiski didn't show to this hearing. She didn't testify either. The decision issued by the magistrate, it's well written, it's obviously in the record and attached, and it sort of speaks for itself. But some other things, important things, are the actual wording of the divorce decree, which is in both of our briefs many times or multiple times. And it actually reserves the right to modify in that portion of the decree, pages 8 to 9 of the decree. And it says that the court specifically reserves the right and retains the right to make any orders at any time in the future necessary to carry out the terms and intention and purposes of this judgment entry and qualified domestic relations order. And again, it talks about the plan being divided by the number of years that they are married. There's also case law that specifically talks about the fact that it's unjust to divide this separate property after the marriage. That's the Hoyt case, Ohio Supreme Court 1990 case. And also the expert, Mr. Myers, testified, and that's on the transcript, page 23 to 24. He was asked whether that was should be separate property, and he agreed. He said, yes, that's separate property, those contributions made after the divorce there. Mrs. Jowiski relies on Walsh to make in her support. Walsh is a completely different situation. It was a military pension. According to the military pension service, you have to be married 10 years in order to divide those two. And Walsh, the Walshes were only married 6 years. So they modified it to extend the marriage to a 10-year marriage when really it was only a 6-year marriage. The court said, no, you can't do that. And I find it sort of ironic that Mrs. Jowiski relies on this, because essentially what she's asking the court to do is extend the marriage from ending in the 90s to ending in 2019, which is explicitly what Walsh prevents. So again, the only testimony at the hearing was the expert, Mr. James Myers, who did testify that the calculation should actually be $287.08 per month, as opposed to what had been previously calculated as a $1,689. Second assignment of error was this contempt issue. First of all, was not objected to at the time. It's transcript page 5 through 7. So I would argue that all but plain errors forfeited. Additionally, there's the Hill case that Attorney Berta mentions. It's a 2009 case, and actually it was, I believe he's corrected in that it's a Northern District federal case. And actually, it was a $2,500 fine in that case, and also the filing fee to file the motions. So in this case, it was only a $100 fine, and Mrs. Jowiski actually had the opportunity to pay it prior, and I want to make sure the timeline's clear. She was ordered to pay the $100 by the next hearing. Because she didn't do that, instead of imposing a jail sentence, the court said, well, no, you need to pay that before you file anything further. So she actually had the opportunity twice to purge herself before the objections that she filed. So she could have, she could have paid the $100 and not even had this provision in there. And then she could have paid the $100 at the time she filed the objections, which she didn't.
Attorney Bremke, am I correct that after that hearing, we have the magistrate's order regarding the contempt and the magistrate's decision regarding the motion in one, it's in one document, correct?
I believe it's either in one document or it was at the same time. I don't disagree. It was done at the same time.
Okay.
Yes.
Okay.
I guess Attorney Berta's argument is that it was, both in his brief and today, was that it was a way to sort of silence the, as far as the content of the objections. But my argument to that is this contempt filing was made long before any of that, any objections were filed. She actually had the opportunity to purge herself before even this hearing, and she didn't. And, in saying she never got one bite at the apple, I don't think is fair to say, because again, there was a way to purge themselves. We all know that's the main thing in a contempt, is that there's a way to purge yourself of it. And, she could have purged herself. The argument that she would waive any objection by doing so is common in the law. That's something that I consult with clients all of the time, that, hey, if you pay this, you're going to waive an objection, but there's always a balancing act. That's not sort of a legal standard. That's just a strategy issue. She could have, paid the fine, or she felt like this was a better argument. Obviously, she didn't pay the fine and wasn't able to object. So again, I would argue that her failure to have these objections properly filed actually go to both assignments of error, because she waived her right to object by not properly objecting to the magistrate's decision, which needs to be objected to in order for her to raise these on appeal. The contempt was proper.
Counsel, excuse me. I'm sorry. I have a question just about the last analogy you talked about in terms of waiving. Is there a difference between paying the fine and waiving your right to object to the contempt versus waiving your paying or not paying the fine and waiving your right to object to a magistrate's decision? Aren't they two different issues?
Okay, I agree with you. She could have paid the $100 and properly submitted her objections. And then the finding of the, this finding of the total overall, what she should receive on the retirement, that could have been properly before this court, but she didn't. In doing that, maybe, that was a strategy to preserve this issue on the contempt. But again, I think that's solely strategy. That's something that is not specific to this case. It's not specific to this area of law. I constantly am representing bondsmen, and they want to appeal a finding by a court. They say, well, if I pay it, then I waive my right to object to it or to appeal it, and I'm going to lose my appellate rights. But if I don't pay it, then they're going to cut off my right to post bonds. And that's something that you have to balance and consider. So, that's not just this area of the law. She made this decision to do this, but waived her right to object to, the overall findings of the magistrate. Further, she never properly objected to this contempt at the time that it was imposed. There was no objection on the record as to this $100 fine, either at the time it was imposed or at the time that it was imposed further, that she couldn't file any further filings, if that makes sense. There's really no difference in finding that, but when you file a motion, you also have to pay a filing fee. And if you don't pay it, your motion is not going to get filed. So this is completely proper, and I would ask that this court uphold the trial court's decision. Again, it's a well-written decision. It's a decision that is supported by law, and it's clear that it's supported by law. The entry is riddled with it, and it's completely proper the way it was done. Any questions?
Seeing none. Thank you, Attorney Bremke. Attorney Berta, you'll have 5 minutes for rebuttal if you wish.
Thank you. Yes, I do, Your Honors. In response to that, Your Honor, the question, and I don't remember which judge asked this, but it is correct. In the September 14th decision by the magistrate, that's when he imposed the $100 fine. He says, if you don't pay the $100 fine, you can't file a motion to object or any other filings. Well, and I looked in my notes, and I have a timestamped copy that was stricken, obviously, from the court by the judge in the lower court. It was filed the 27th of September, objecting. Well, that was stricken completely off. So there was no way to challenge the $100 fine, nor was there any way to challenge the division of the QDRO. So, Your Honor, I believe that was plain error. That was based upon passion. And I understand a judge protecting his magistrate from unwarranted names. And I think that was an improper calling. I didn't know what the initial stood for. MCP. I don't know. I was told that's what it meant. I have no reason to doubt that. It means male chauvinist pig. However, she never got that one bite of the apple at all. And indicated in the decision that the court relied on, the lower court, as well as the appellee in the Northern District case, that was a case that, as indicated, that issue was addressed. He filed 19 times to address the same issue. The court finally said, we've addressed this 19 or 18 times. You filed motion for leave to plead again. You're not going to do it on the same case until you pay this fine. That was completely different type of situation. This is one time. We were saying, we're not even going to let you appeal until you file an objection or until you file the $100 fine. So not, in essence, you have to acquiesce to what we've told you to do before you let us speak to us. This wasn't a filing fee, Your Honor. This was a fine levied against her for contempt, which was objected to timely along with the QDRO. However, the court would not let that proceed. And after that point in time, the only recourse was the Court of Appeals. So, Your Honor, in addition to that, which I think was plain error for the court to do that because it was based upon passion. As indicated, I completely understand why a court may want to protect magistrates in the whole judicial system based upon how people act in front of it. I completely understand that. However, as all these judges know, and Ms. Bremke and I know through years of practice, it doesn't always go like we'd like it to. Not everybody's polite. Your Honors, and I just want to refer briefly back to my brief, I think it's so important for it to go over to page 6, which highlights the transcript of the actual hearing. The expert for QDRO actually indicated that was a proper QDRO based upon the wording of the decree. It was completely proper. The appellee made a mistake. He kept contributing a lump sum to his retirement plan after the divorce. He admitted he could have just had a separate retirement plan, but he went through that. And then based upon that, they didn't determine, well, this was after or before. It just went in and expanded his whole retirement plan. It was a very sweet deal he testified to, and I don't blame him for doing it. He got like 3 to 4 times the retirement plan that he would have normally got. It was offered for a very small percentage of salaried workers, he testified. He did that. However, it made her plan increase too, because that amount in grew her proportion over time. As they testified, over time, that initial money put in based upon the market grew, and her share grew because of that. So it was a proper QDRO. There was no reason to modify, and I believe it was a modification by writing a new QDRO if we do that. And I believe that Ms. Gustafson had the ability to object to the magistrate's decision based upon the $100. I mean, I'm not silly. I know that the court in all likelihood would have affirmed that, and she would have paid that. However, taking away that right to object to it is a terrible miscarriage of justice in this case, and judges have to be kept to a strict standard as well as litigants. I thank you for your time today.
Thank you both for your presentations today. The court will take the matter into advisement. We will issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website.